Good morning. Happy Thursday. I got lost a little bit reading some of the things posted on Blind Justice's community page. Someone linked me to it or directed me to it, and it's a feast. It is a sovereign citizen feast. Tasty. In it, through his attorney, which I commend Blind Justice on having an attorney in the first place. Through his attorney, Blind Justice apparently recommended accommodations under the Americans with Disabilities Act, including to go into court with, because Blind Justice has PTSD and he's blind and he has a small penis and an inferiority complex. I'm guessing on the penis part. But because he has those, he needs certain things to go into court with. So he needs not one, but two. Hey, it's a skunk. Two Bluetooth headsets. Not one, but two Bluetooth headsets. Because, PTSD. He needs one for his PTSD and one because he's blind. He needs his cell phone, his selfie stick. Got to have a selfie stick. It's his whoopee. He needs his GPS or GoPro on his chest strap. He needs to wear his ball cap, He needs his ball cap, guys. I'm guessing he has a bald spot, but I don't know. He needed a bunch of other things. Sunglasses. He needed his sunglasses. A couple other things. His whoopee of some sort. And so he requested these things through his attorney. And the judge accommodated some of the things. Some of the things he did not accommodate. Like he said, okay, fine, you can wear your ball cap. And you can have your sunglasses. And I think it was one or two other things. But he couldn't bring in his camera. He couldn't bring in his cell phone and his selfie stick. He couldn't bring in his not one but two Bluetooth headsets. He couldn't bring in a lot of things. So after getting that rejection, apparently in his infinite wisdom, he decides to then write the judge himself and bypass his attorney, which causes a real conflict because, believe it or not, judges aren't supposed to communicate with parties. They're not supposed to do that. If you're in pro per or pro se, which both mean essentially the same thing, just typically you use pro se in federal court, and at least in California, state court, you say pro per. Same thing, different name for the same thing. But if you're appearing pro se, then yes, you can communicate with the judge as long as you also include the other side. If they're pro se, then you have to include the party. If they're represented, you have to include the attorney. But if you are represented, then all communications to and from the judge have to be through counsel. That's what you pay. That's what you pay your attorney for. But he didn't. So he writes to the judge and he says, you have to prove. He cites an ADA section that does in fact say that you can't just deny someone their reasonable accommodations under the ADA. Again, note it, they have to be reasonable. You can't just deny them, you have to prove it, right? And the judge writes back to the attorney because, again, the judge isn't supposed to be communicating with the represented party directly. So the judge writes back to the attorney a scathing letter, essentially saying, look, dude, if you're representing this guy, you need to get him under control and stop communicating. We've done what we're going to do, and that's it. If he doesn't show up, he's going to be or if he shows up with any of this crap that he's not supposed to have, he's going to be held in contempt. And then the pièce de résistance is a would they call it, a remonstrance to the House and Senate of North Carolina, seeking to have the judge impeached, citing various sections of the Constitution of North Carolina and referencing various federal laws. It's all very humorous. Some common mistakes that are being made. Number one is whenever a statute or something says you need to prove something, that means in court. You have to prove it in court at the appropriate time, not at the arraignment. I mean, they don't have to prove jurisdiction over you at the arraignment. They have to allege it at their arraignment. The trial is where the proof comes. And they don't have to prove it to you. So if it says they have to prove it, or if there's some sort of statute that says they have to prove it in court to the finder of fact, not out of court to you. So that's a big thing that not just blind justice, but other sovereign citizens tend to mistake. And the other big mistake that they also tend to make is they read a statute or they read a constitution and they interpret it the way they want to interpret it, and so they cite it. And that's a very common mistake, because a lot of sections of constitutions and a lot of statutes have been interpreted by courts. You really do need to find that case law that gives the interpretation that supports what you want it to do, and not just cite the raw section of the Constitution or what have you, because oftentimes it doesn't mean what you think it means. Finally, someone linked me to a clip of someone who called to the sheriff's office trying to talk to the sheriff. A guy named Karen. It was kind of weird. I think his name was Karen. I forget exactly what the name on the account was, but it was definitely a dude with a gal's name. Anyway, he called himself a pro se attorney. Now, pro se means I am representing myself. An attorney is someone who's licensed to practice law in whatever state. So a pro se attorney would be an attorney who's representing himself, but then he says that he's representing somebody else. So that was really weird. It's a lot of word salad from someone trying to sound more important than they are, when in fact they're not important or educated. Anyway, thanks for watching. Have a great day.